everybody. This is Samantha from the law offices of Samantha Wolfe, and I'm here for a virtual seminar. Thank you for coming to check us out. We do have virtual seminars that we post on our YouTube channel that you can access through our website, so hopefully you found us through one of those means. But today I'm going to start a new series. I'm excited about it. The staff at my office, they were brainstorming different seminar ideas, and one of the things that came up was a skeptics series. So we're going to do a series of presentations and virtual seminars on different topics where we present the skeptics questions and I answer them. So I'm excited, hopefully that you get a lot out of it. Some of it is going to be taken from actual client questions that we have had at our office. So today we're going to focus on trust. So let me pull up our presentation here. And today we're going to talk about, let's see, there we go. Okay, today we're going to talk about trust. And I'm going to answer some skeptic questions related to trust. So here is our mission statement. We've talked about this before. A lot of the reasons that we like to do these seminars is just to continue to provide resources and services to our referral sources and our clients. So we do get a lot of skeptics in our office, and one of the challenges that we have is talking through their questions. And it could be that they've been searching online. It could be that they have a financial advisor that they've trusted that maybe has presented some pushback on some different planning techniques. Could be family, friends, people that they've talked to. So I'm going to try to answer a series of skeptic questions. So we have our little skeptic at the bottom of the PowerPoint. He's to represent our clients that have these questions. And so our first one, today we're focusing on trust, the skeptic's questions related to trust. So today's question is, I have a trust, why do I need a will? Now this question, I didn't have a whole lot until recently, and I've had a couple of clients where we have done a revocable living trust with the purpose, the specific purpose of avoiding probate. And so we create the trust, we fund the trust with assets, and the question was then, well, why do I need a will? And I like to explain it this way. So my goal is to take inventory of all the assets that you disclose to us. That's why we ask you to do an intake sheet, to figure out what assets make sense to transfer into the trust, create the trust, and then help you transfer those assets to the trust. The issue that we've run into when someone passes away and we're administering the estate is sometimes after I've met with a client, they acquire a new asset and they don't title it in the name of the trust, or they forgot about an asset. Usually it's savings bonds or stocks that they didn't remember to disclose, and those assets are outside of the trust. And the problem is that unless the asset is owned in the trust when you die, then it's going to be distributed according to the will if you have one, or according to Pennsylvania rules of intestate if you don't have a will. So I look at the will in conjunction with a trust as the belt and suspenders approach. The goal is to create the trust, transfer all the assets into it, but on the few circumstances, and we have had them, where you haven't transferred an asset into the trust, whether it be you acquired the asset after, or maybe you didn't disclose it, that's going to pass through your will. And if we don't have a will, then we're under Pennsylvania rules of intestate, which can be a little bit more cumbersome. So that's why I recommend that you do a will and a trust. It could be that your will just says, hey, to the extent that I have assets in my name when I die, pay it over into the trust if I have a trust. But I always prefer the belt and suspenders approach. Next skeptic is, my trust is signed. Do I need to create a new bank account now? This depends on the assets that you're transferring into the trust. So sometimes we have clients who put real estate in trust. Sometimes we have clients who put real estate and monetary assets into trust. Sometimes we have clients that just designate the trust as a beneficiary on certain accounts. So a lot of the recommendations that we make are specific to our clients. So you may need a new bank account in the name of the trust, but that would only be if you're going to be receiving funds that are titled in the name of the trust. So for example, sometimes we have clients that transfer rental property into a trust and they're receiving rental income. Technically, that rental income is now payable to the trust. So we need a bank account titled in the name of the trust to receive those funds. So in that case, we would need a new bank account. In the situation where a client's just transferring their primary residence, however, and they're not going to be receiving checks payable in the name of the trust, we probably don't need a bank account until or if they would ever sell their primary residence and then the check is being made payable to the trust. At that point, then our client would create a bank account. So always make sure to ask if you're concerned about that, but we do try to make sure to give specific instruction if we do need a bank account created. The next skeptic question is, I have a lot of properties, how many trusts do I need? This is specific to the situation. So trusts do offer creditor protection if they're irrevocable. So I might tell a client that has multiple rental properties to use multiple trusts and to transfer each rental property into the trust so that we can get some asset protection. It would be like creating a separate LLC for each rental property. So I might recommend that for some creditor protection. So you might end up with multiple trusts. The good news is at our office, we don't charge per trust. We charge for the plan that we're doing. So usually if we're recommending multiple trusts, that's all included in the flat fee that we've quoted our clients. But it might depend on how many properties you have and if there would be any creditors potentially in play. The next skeptic question, this one I got specifically from a client, and they had met with their financial advisor after I had talked to the client and worked through their concerns and made a recommendation. And the financial advisor talked to the client and had said that irrevocable trusts are bad. That there's no reason you would use an irrevocable trust. And so the client came in and said, my financial advisor says irrevocable trusts are bad. So why are you telling me something different? And the reason that I might be telling you something different is you might have told me that one of your goals was nursing home protection. You might have told me it was creditor protection. You might have given me a specific reason why I'm recommending an irrevocable trust. The good news is that if we're recommending an irrevocable trust for nursing home protection or creditor protection, there's still a lot of flexibility in that irrevocable trust. And financial advisors who aren't experienced in this area are not going to realize that even though it's irrevocable, the client can still serve as the trustee. The client can still add and remove beneficiaries. The client can still add and remove the trust protector. And so from our perspective, irrevocable trusts are a very powerful tool. And if we're making that specific recommendation, we are making that recommendation because you asked us a question where an irrevocable trust provides a very viable solution for that question. So in this case, what we ended up doing is that we did try to loop the financial advisor in the conversation. I did tell my client, I said, I love working with financial advisors. I consider them great teammates. And a lot of times the financial advisor is going to be the quarterback of the team because they have a long-standing relationship with the client. Where it sometimes gets a little bit difficult is if the financial advisor is trying to weigh in on legal recommendations. And this is what I equate it to. I'm not going to give financial advice because I'm not a financial advisor. So if I'm making a recommendation, I don't mind if the financial advisor questions it, but it needs to be in an atmosphere where we can explore it all together, because it becomes very difficult if the financial advisor is saying one thing, but I'm recommending something different. And so if I'm making that recommendation, there's usually a specific reason for that recommendation. Our philosophy at our office is let's always keep the estate plan as simple as we can while still accomplishing your goals. So I'm not going to recommend an irrevocable trust unless you said there was a specific thing that you wanted to accomplish that maybe only an irrevocable trust can accomplish. So that would be why. Oh, I skipped ahead here. Okay. So let's go to the next skeptic. I have a revocable trust, so why do I need an irrevocable trust? So let's talk about that a minute. We have two main types of trust. We have revocable and we have irrevocable trusts. Revocable trusts are typically used for probate avoidance, meaning that you don't want to have an executor appointed. You don't want your assets to have to go through the court system to be distributed. That would be a revocable trust. Another reason you might use a revocable trust is because you've expressed concern about maybe leaving it to your children and having it be held in trust for the children so they have some protection. So I might have recommended a revocable trust for that reason. But the downside of a revocable trust is that it offers no creditor protection. And as we age, the biggest creditor is a nursing home. So if you have a revocable trust, those assets are not going to be protected against nursing home costs. So if you have a revocable trust, and some clients have it and think it provides nursing home protection, and it does not. So if you have a revocable trust, we might be recommending an irrevocable trust for that nursing home or that asset protection planning that you might be looking for. The next skeptic is, I have a revocable trust. Do I have to do a whole new trust to make it irrevocable? The good news is, no, you don't. You can have a revocable trust that we make irrevocable, and we're able to do that because in a revocable trust, typically you've retained the ability to add and remove beneficiaries, to change the provisions in the trust whenever you want. And if we have the client give up the ability to make those changes whenever they want, then it can become irrevocable. Now, the caution here is we want to make sure before we change it from a revocable to an irrevocable trust that we have the assets in there that we're okay with the irrevocable provision. So for example, I don't typically recommend an everyday checking account in an irrevocable trust because usually we're creating a structure so that it's protected against nursing home costs, and you don't want to have your everyday checking account in that irrevocable trust. So I might tell you we're going to transfer some assets out of your revocable trust before we make it irrevocable so that you have the flexibility for the certain assets that you want the flexibility for. But the good news is that you can change a revocable trust to an irrevocable trust without creating a whole new trust. Okay, I'm sorry, my fingers are all excited about these skeptic questions and they jump ahead. The next skeptic question is, you're telling me to do an irrevocable trust, but I read online that means I can't make changes. Why would you recommend that? So again, if we're making that recommendation, it's because you've told us something specific that you want to accomplish. The biggest thing is the nursing home protection aspect, and we can only get that with an irrevocable trust. Now, that type of trust, one that's irrevocable, specific for nursing home protection purposes, you still, as the client, have a lot of flexibility. So if you get online and you search irrevocable trust, you're going to see all kinds of things about how you have to get a separate EIN, how it's subject to higher tax rates, how you can't make any changes. What is important to remember about irrevocable trusts in the context of asset protection and nursing home protection is you as the client can still have a lot of flexibility. So depending on the state, you can still be the trustee, you can still buy and sell the assets, you can still invest it and manage it the way you want. It's just you can't make distributions out of the trust, because if you could do that, then the nursing home could attach to those assets. So if I am making that recommendation and you're nervous about changes that you'd want to make in the future, then just make sure to bring it up, because 9 times out of 10, we can make whatever change you would want, even though the trust is irrevocable. And that's because the way we structure them, the client is still the trustee, and they can still choose to buy and sell real estate if it's owned in the trust. They can choose to buy and sell stock or invest it however they want. The difference is that if they wanted to make a distribution out of the trust, we structure it so that you have to have someone else make the distribution at your direction. And if they don't make the distribution, you can fire them and appoint someone else. But the benefit there is that then you get the asset protection that you're looking for. So a lot of families, like for example, my parents, they created an irrevocable trust, and they have my sisters and I as the ability, having the power to be able to make distributions out of the trust if they would request. And if I would tell my dad no, he can fire me and appoint someone else to serve in that position. So even though it's an irrevocable trust, it's It's very flexible. The other thing he can do is add and remove beneficiaries, which you can't do with most irrevocable trusts. So what I would caution you from doing is to jumping online and reading about it, because if someone tells you that they have a trust, that's like saying they have a car. It doesn't tell you the make, model, the year, what features you have in there. So a general irrevocable trust could mean anything. It might be that you have those stipulations and restrictions that you see online when you search, but it could be that no, we're just trying to do nursing home protection, and so you still have the ability to serve as the trustee and make the decisions about buying, selling, adding, removing beneficiaries, all of that good stuff. The next skeptic says, I want to protect assets, but I need the income to live. Am I out of luck? The good news here is that if we would recommend an irrevocable trust for nursing home protection, there are two categories. We have one where you can still get the income, the interest, the dividends that are generated off the assets owned in the trust, but you can't get the principal, so that's protected. Or we can create the trust where the income and the principal are both protected, which means that you would need that trust protector, your kids or someone else that you trust, to make that distribution out. So we can actually set it up either way. So just because you want the income to live off of, it does not mean that you're in the situation where you can't protect assets. You absolutely can. The next skeptic's question is, why should I do an irrevocable trust when a revocable trust is cheaper? So in our office, we do flat fee, but the way it works is that a revocable trust is just probate avoidance. An irrevocable trust, we're avoiding probate and doing nursing home protection. And so because we're doing multiple things with it, typically an irrevocable trust is more expensive. And so clients always ask that, why is it more expensive? And the reason it's more expensive is because it takes us more time to draft it. It's a more technical draft. We have to make sure we have the provisions correct, and we have to make sure we're transferring some very specific assets into the trust to get the nursing home protection. So the reason that you would want to do an irrevocable trust is because you want more than just probate avoidance. And typically that means that it's going to be more expensive. Best metaphor I can make is that it's like you have a car, and one car has more features in it that might make you more comfortable or might address a need that you have. And so you can do the more basic model, you can do the revocable trust, and it's going to be cheaper, but then you might not have all the bells and whistles that you want. And so that's why we might recommend an irrevocable trust, even though a revocable one is less expensive. Next skeptic, I don't care if I leave money to my kids, so why would I do an irrevocable trust? I get this a lot. And what I tell clients, and usually it's a husband and wife, is I ask them if they're worried about their spouse. And the reason why this is important is that most couples, most families where we're doing irrevocable trust planning, we're not actually doing the planning to protect the money for the kids. We're doing the planning to protect the money if one of the spouses would need care. So, for example, if husband would need nursing home care, we don't want to leave the wife financially compromised. So we're actually doing an irrevocable trust so spouses can protect each other. So currently in Pennsylvania, spouses are only allowed to keep about $162,660. So if one spouse needs care, the other spouse can only keep that much. And so if we use an irrevocable trust, we can make the non-institutionalized spouse, the one that doesn't need the nursing home, more financially comfortable or more financially sound. And so we don't always use irrevocable trust to protect the kids. We're using irrevocable trust to protect the spouses if one of them needed care. The next skeptic question, this is one that I had from a client who had talked to their financial advisor. And so the financial advisor says probate in Pennsylvania isn't that bad, so why would I do a revocable trust? What was interesting about this situation is that the financial advisor was actually based out of Florida. And what I can tell you is that every state has different rules when it comes to probate. So Florida is a state that has more strict and more expensive rules for probate. But in Pennsylvania, if you've ever had to serve as an executor, you know that it takes some time and that it can be expensive. And so it's not the probate is bad. It's that we have to stop and think about what are we trying to accomplish, and does the trust do that? So when some some financial advisor in Florida says probate isn't that bad, they're right. But the issue is that Pennsylvania probate still has a lot of requirements, and most everyday people don't know what those requirements are. So they hire an attorney, which is completely understandable. And the attorney is going to have fees. So even though the probate fee itself isn't as high as it is in Florida, Florida can be thousands of dollars, and in PA it's typically hundreds of dollars. The issue is in Pennsylvania, just like in Florida, is that if you hire an attorney is typically going to charge hourly for the time that it takes to help with the probate process, or they're going to charge a flat fee. And either way, usually, in most cases, you're looking at a minimum of $5,000 to $8,000 to probate. And so when a financial advisor says probate in PA isn't that bad, they're correct. The filing fees aren't that bad. But if an attorney or an accountant or any other professional is going to be needed to help provide support, the attorney's fees or those professional fees can start to add up. And so we do a revocable trust, knowing that yes, the client may be paying us now to create the trust. The thought being that on the back end, when they pass away, the attorney's fees won't be as expensive. And so again, it's understanding what is it exactly that causes the cost in Pennsylvania to be so high. Now, an executor might be able to do some of the tasks and reduce the fee, but usually you're looking at thousands of dollars to probate. And so that's why we might recommend a revocable trust. The next skeptic question, I will have sufficient income or significant income in retirement. So why are you recommending a trust? And this is one I had recently. And it was husband and wife, and the husband had quite a bit in retirement, and the wife didn't have as much. And what I explained was, I'm recommending a trust because if the husband needs nursing home care, all of his retirement is available to pay for his care. And if all of that money goes to pay for his care, what is the wife using to live off of? So yes, you might have sufficient income in retirement, but what about your spouse? Because unless we can show that your spouse needs your income to pay bills, mortgage and utilities and fuel or heat, then the nursing home is not going to allow us to shift income to the spouse that's not in the nursing home. So when we're looking at income, yes, I am looking to see if we have sufficient income, but I'm also looking to see, is there a big disparity between husband and wife's income? Because if husband is the one that has the higher income and he goes into the nursing home, his income is going to go to the nursing home, and then wife won't have sufficient income to pay for her needs. And so sometimes, even when one spouse has sufficient income, we still might recommend a trust. The next skeptic question is, my children are responsible, so why would I leave their distribution in trust rather than outright to them? So there are two ways that you can distribute your estate. You can either say that when you die or when you and your spouse die, it goes outright to beneficiaries and then they receive their inheritance and do whatever. Or you can say that they receive it in trust and you might have certain restrictions or stipulations, or it just might be in trust to give some creditor protection. And so we might do that because even though your children are responsible, it gives them more protection to start off with because they never owned it individually. So because it's in trust, they start off with more protection. And then if the kids are responsible, they can serve as their own trustee and they can pull money out for whatever they need, but it starts the children off in a place of having protection. It also means that if your children are responsible and something would happen to that child, you get to say what happens to the remaining inheritance as opposed to it going to that child's spouse or going to that child's will. So that's why you might want it to be in trust rather than outright. Okay. So I zipped through them. I think we had about 15 maybe skeptics questions. And if this is helpful, which I'm hoping it is, we can always do more. Like I can do a part 2 of questions related to trust, but these were the top 15 that we had kind of seen in our practice over the last year. We will do, next month, we're going to do another skeptic, and it will be related to another topic like estate administration, deeds, estate planning, powers of attorneys, those type of things. And hopefully we can answer maybe some questions that you've been thinking about. You can always call our office at 717-655-2676 to schedule an initial consultation. We have our address there for our office, and you can always check out our website, which does take you to our YouTube channel. So you can check out all those videos. Okay, let me stop sharing here. So I hope that this first skeptics seminar was helpful for anyone who was watching. If you ever have any suggestions, we're always open to hearing about them. But thank you so much for joining us. We hope that you have a great day.